Hello, I'm Angela Princewell, and I'm joined today by Tavinda Ballas and Shireen Abdi, and we're going to be talking retirement. If you're thinking about retiring, great for you. I hope it's the start of an exciting new chapter. Of course, I know that it's not always voluntary, but regardless, it's hopefully it's an opportunity for a new chapter and great things to come. If you're separated, however, we can't just focus on the fun, exciting part. We have to think about the legal consequences that flow from that decision to retire. And that's what we would like to talk about on today's segment. So I'm going to start with you, Tabinda. What should a person be thinking about, a separated person, if they're looking at retiring?
That's a very good question. Thank you, Angela. So, first of all, it's important to see whether there is a current court order for child or spousal support and or a separation agreement. If there is, then the next thing you need to consider is whether there is a provision that allows you to have your support obligation reviewed, right, upon retirement. Just one thing that people need to consider, I mean, if you're retiring at an age that is that sets the basis for material change in circumstances, right? So unless, again, if it's a contested issue, then you may need to commence a motion to change. But first, if there's a separation agreement and you reach out to your ex-spouse and try to work it out, negotiate, that's always the best solution. If there is no order and say things are not you guys are not communicating well with your, things are not going well between you and your ex, then an application to start
You have to need an
right?
application definitely to deal with the issue and all that. Yeah, so I guess in that context, you're thinking there's a separation agreement, and yeah, you still would need to have that temporary, because to be honest, if there's no agreement and no court order and you were just paying this from the goodness of your heart, then it's like, okay, now I'm retired, I don't have to pay anymore. Well, we never see those cases, so.
Right. The other thing I think sometimes people need to be mindful of is early retirement too, Angela. Like, say you're retiring at 55 or, at an age where
Even
you're not
65. I have seen people argue that retirement at 65 is early. There's case law for even 73. So that's something that, yeah. But I
it's
would
case
like to
by
think
case.
65 is the right age. That's my thought, but not
Right.
necessarily.
Not
Right.
so exactly, like that's where the other party really contests and raises concerns. And again, it's a very gray area, it's fact specific based on the circumstances as to why you're retiring early. The court may or may not decide in your favor.
Absolutely. And that's why it's important to seek legal advice before you do, right? Shireen, I'll let you run with that one.
The legal advice or just
Yes,
retirement as a
because
whole?
no, in general, but I mean, I think Tabina kind of left us with, the importance of seeking legal advice, because you and I have seen a lot of files where a person comes to us after they've retired. And I think there's a lot of jobs, unions, I think it used to be firefighters. I don't know if that's still the case, where they could retire at 55 or 60 with an unreduced pension. And so for a person, like if you've been working, for any number of time, like, come on, you have an unreduced pension, you're going to take it. But
Yeah.
obviously the unreduced pension doesn't equal your income. So you have a lower income. There's somebody else that relies on that. Now, what happens, right? Does the court automatically say, well, you were entitled to retire, so that's it? Or does your obligation to pay support continue?
That is very fact specific. And of course, it depends on the nature of your pension and your job. So, in the example that you used as a firefighter, that requires mobility. If you have a medical condition where you're not able to perform in the same tasks that you were, potentially retirement and, for medical reasons might be actually a viable and the only option. But from a legal perspective, the court's going to want to expect that you've taken every avenue possible before retirement is the only option. Is there a desk duty job that you can do? I believe there's an actual word for a desk job, but essentially just, are you on modified duty? That's the word that, or the words that I'm looking for. Is there a modified duty? Is there long-term disability available through your employment? It doesn't have to automatically lead to a pension. Of course, sometimes employees might not get that option, right? But those are all factors that need to be considered. But in terms of getting legal advice, it is incredibly important. I've had, actually just recently, I've had a client retire at the age of 57 years old, just didn't feel like doing the job anymore. And while that might be from an emotional perspective, and the spouse at the time, even though they were separated, agreed. But now that both parties have counsel, it's an entirely different situation, right? So, well, I want to say right as if you're aware, but just so that there's a lot of legalities regarding, what should my client's income be and what that would look like. And obviously, was there a need to retire? Was there a significant need, and what that looks like, the medical evidence to support that? So it's so important to get legal advice to know whether or not the circumstances to which you're retiring. And I wouldn't advise to just retire. I would always say seek legal advice, especially if you have existing support obligations. And, for example, if your support obligations are spelled out through, FRO, and you're paying the other party directly pursuant to a court order, and you just unilaterally stop, there's enforcement measures that are taking place. They're not just going to automatically vary your support arrangements because you've retired, unless that's set out, of course, in your agreement. So there's a lot to consider.
Yeah, I mean, that's 100%. Yes. And I think I want to go back to those people who want to retire, not for medical reasons, not for any reason besides, the fact that they can, right? Like a lot of people get these jobs and look forward to being able to retire early and they have no medical reasons. And I've had clients where their upon retirement, their spousal support obligation was essentially their retirement income, right? So if you pay support, then you really have nothing to live on. So I think you need to be very careful there. But let's even go back and on this age of retirement and thing, let's talk about some jobs because I know there was a case law where there was a person, I believe it was a physician that was 73 years old, and the ex-spouse would not agree for spousal support to be varied because she did not think that he should be retiring at that time. So that's pretty, interesting. Like, Tabinda, what do you think about a reasonable, if you were arguing for your client, what would you think a reasonable age of retirement should be?
Really, I would go with the age of, I want to say 65 is reasonable, and arguably between 60 and 65, right? But again, for medical reasons. But just to circle back, Angela, to the case law, there's a case law from 2004 where an RCMP officer wanted to or retired early because of stress and other physical ailments he was experiencing. And the court ended up imputing his income for early retirement. So it's again, we don't like there's more to it. There are more details, but just to kind of highlight, when you're thinking about early retirement and with or without medical reasons, you have to be very, very cautious. It may be that you may be ordered to pay a support based on your imputed income until say the age of 65, and then come back and challenge it, right? Or request for variation.
Yeah. So I want to take this now in another direction. So if you've not learned anything so far, you know by now that you need to seek legal advice before you take this step, and that there is no consensus on the retirement age, and that your ill health may still not be enough to exonerate you and allow you to retire at whatever is deemed the appropriate retirement age for you. So I think that's pretty much what I'm going to summarize that we've said so far. It's not that grim, so I don't want to discourage anyone, but again, with family law matters, a lot depends on kind of the facts of your specific case. But I want to take it in the direction of let's imagine that we're representing the spouse that's receiving spousal support, and now the other party's telling us they want to retire. So, Shireen, what would you be looking for? What would you want to see for your client when looking at, that would I say claim for variation?
I would look at, obviously, if these parties were married or in a long-term relationship, I would look at any compensatory element of support, because just because retirement, is one factor doesn't mean it support automatically terminates. So it's not, just dealt with in a vacuum that way. So it's dealt with, and just looking at, okay, if they do in fact retire, I'm accepting, is it under the guise that I'm accepting that this person is retiring and now I'm
No,
now dealing with
you
it?
may go in the direction that,
Okay.
yeah, you know what? Yeah, go in that direction because they may actually not be retiring, correct?
Oh, no, I mean in this, okay, yeah. So if they're not retiring, obviously, I don't have to deal with the reduced pension,
No,
the
no, what
reduced
I mean
income.
is we've had scenarios where people say they're retiring, but then we know they may become consultants, for example. So
Oh, okay,
I
yes,
thought that's what you
those
meant.
are interesting. So in that scenario, I would look at the support amounts. So obviously, if the parties were married, they would have equalized their assets. Of those assets would have formed, I imagine, a pension. That pension is also what that person is going to draw on for the retiree person is going to rely on from an income source from a pension perspective. So obviously they'll be out operating at a reduced income capacity, but they would still be able to draw on, their pension if they have one through their employer, or CPP and OAS if that's available through the government. But there's also RSP income and RSPs that would be reduced as well, because you're able to now draw on portions at a lower taxable rate. And I think I'm confusing everyone, but ultimately to say that the retired individual would have other sources of income, or the retired income is now the aspect that I'm going to be looking at. Obviously, counter to my client's need for spousal support and the ability to pay. So I would be looking at both of those competing interests. For me, when dealing with property, or for most lawyers dealing with property that's already, or a pension that's already been equalized, we're now looking towards the portion of the pension that was not equalized, and looking at how, and obviously this involves, pension valuations and things like that, as well as maybe an actuary to determine any income generating assets that that individual has, to determine what would that person's income be from a retirement perspective. And if the concern is that they're going to not really retire, then I would definitely make sure that that's stipulated in an agreement where they would do an annual review. So, if it's going to be, okay, fine, he'll pay maybe no spousal support for this period of time, it would be subject to an annual review with annual disclosure to make sure that my client feels satisfied that they're not going to unilaterally work. Of course, there's a concern about even working under the table, but maybe an in-depth analysis of bank accounts and things like that on an annual review.
Okay. Yeah, I think that pretty much covers it, because when you've talked about sort of the double dipping, and that concerns everyone that's trying to get retired. They want to make sure that they're not splitting the same assets that have already been equalized. And I like that you looked at it from the other side as well, right? Because if you want to look at what income sources are available to the spouse, to the support recipient, I should say. But what income sources are available to you, and what income is also available to the other side. And it's we have seen cases where a person might have significant assets, they're not drawing from it because they have this support income coming in. And if you're, again, case by case, right? If you're 50, it might not be appropriate for you to start drawing down on those assets, right? Given the life expectancy, thankfully, that we have in this country. But if you're 65 and sitting on significant assets, then it's reasonable to terminate support and you begin to draw from those assets, going forward. So the answer that would be given to, say, if someone in their 50s is completely different from someone in their 60s, and depending on the amount of assets that are available and things like that. Now, there's also the question of income generation. Well, actually, Tamina, I don't know if you wanted to add anything before I jump from this topic.
No, I think Shireen and you covered it all. Thank you.
Okay. So income generating assets, right? So how many times have we had to make this argument that, well, the recipient received $1 million? No, let me even make this more interesting. The recipient spouse received a property that they could have, generated income from. So let's call it even the matrimonial home. Could they generate income from renting out the basement, for example? And so, those are the things that a court would look at, right? If you guys want to weigh in sort of on that.
Yeah, so it's not going to be just that, hey, I have a need for spousal support, it should continue, the end. It's not really, and then I'm saying this from I'm representing the other side here in this scenario, but essentially, if you are the support recipient, it's also mindful to just factor in or know that it's not just his income or her income from a retirement perspective that's going to be taken a look at. It's also the assets that you got as part of the equalization perspective, what you did with those assets to make sure that they were, fueling, investment income or basically generating a profit. What did you do with that money? What kind of assets can you draw on? And also, is there a continued ability, if your spousal support continued basis is that you have a needs-based ability, and your continued need for spousal support as opposed to a compensatory element of spousal support, then we're going to look at your expenses. If your expenses are low, and you have more than enough assets to draw on and income to support yourself and be self-sufficient, the court's also going to take that into consideration.
Yeah, absolutely. The last thing I kind of want to touch on is this thing of lifetime versus indefinite duration of spousal support. So every once in a while, when someone wants to retire, the recipient comes up and says, well, my support is for an indefinite duration. To be clear, indefinite is not the same as lifetime. And you would have the recipient so strongly express to you that he or she was supposed to pay spousal support for their lifetime, right? And it's not necessarily so. I have a few times seen agreements where it's actually stated that support would be paid for the recipient's lifetime. So
Wow. Really hope
yes.
they were close to the end of their lifetime as the support
Yeah. Yeah. I mean, it is, I've seen that a few times. I have tried to argue that that's, well, but that's a different topic. But just for our purposes, just know that lifetime is not the same as indefinite. So the fact that you have a support agreement that says it's indefinite, as a recipient, don't think that that means, the payor cannot retire or whatnot. It just means that for your support to be, there's no end date. Let's just put it that way. It just means there's no end date, and that it will be open to a conversation at the time at a future date as to whether or not to terminate or reduce support. So let's say someone comes to us and it's not, how do I put this? So they didn't talk to us on time, and now they've retired and they have this income. There's still the solution of saying, well, negotiating a reduction in the spousal support, right? Even if it doesn't get terminated. I know, Shireen, you had a file not too long ago where I think that was sort of your solution, negotiating a reduction versus
Yeah, there was multiple solutions that could have been, targeted. The best option for my client was cash at hand. So he wanted to ensure that he could still make, monthly payments. So we negotiated a reduced amount of support so that way, and then also stipulated when he could actually retire. So an end date, as well as also something that I always say is like liquid gold for me, an end date of support. But yeah, you could always do a reduction. You could also just say, okay, you could calculate maybe, a certain fixed period of time and pay a lump sum to just end it, so there's different ways to deal with it.
Yes, that's a good one. And if you're a recipient that's also thinking of or a payer that's thinking of getting a termination date, don't there's only so much we can insist on it. And I have had clients that would say things like, well, let's put in there that support would end at 65 and things like that. And that's great. And we want that certainty for you. But if you're in a long-term marriage, if your marriage is over 20 years, you're not likely to get an end date. It's just not going to happen. Now, if you're able to negotiate that liquid gold for yourself, fantastic. And that's good for you, but that's not something that's likely to it's not something that the law you would get in a court. It's not don't try to litigate that issue. A court is not giving you an end date under those circumstances. Negotiate it if you can. Otherwise, put in mechanisms for a review or something, which is kind of goes without saying. Oh, that reminds me, is retirement necessarily always a material change? Because we forgot that's actually a threshold issue that we didn't think of.
Yeah, I mean, to be
I
honest,
mean,
it's
now what do you
arguable.
think? I want to
Oh,
see
go
what
ahead.
Taminda, I could see her eyes like thinking, do you think it should always be a material change?
I don't always is a really tricky word. So I will say it may be a reason for a material change, right? Or it may be considered as a material change. But there's no hard and fast rule in family law, right? So you always have to, again, look at all the facts and situations and take steps accordingly. I do want to circle back or just add one point to what you were saying earlier, Angela, with respect to the orders or a separation agreement, having a termination date if there is or isn't. If an agreement is silent on on the issue of retirement, then that kind of leaves the door open to bring a motion to change, right? So you have to consider, you have to look at when the separation agreement was drafted and whether it talks about termination or not, or retirement or not, and that may be an open door for you to commence a motion to change.
Well, I would not be doing you justice if I don't throw in and make this any more complicated. So let's say, Payor is 60 something years old. Let's say Payor is 64, and at the time the parties had been discussing. Well, no, at 63 the parties separated. And all these years, for years leading up to 63, the parties had been planning for, this retirement party that was going to happen when the payer retires at 65. And then now they've separated at, payer 64 enters into a separation agreement. And it's silent on retirement. Shireen, could you possibly argue under those circumstances that there should be no review because they knew it was foreseeable that retirement was coming on. No one discussed, they were silent on it. So maybe it shouldn't constitute a material change. Would
I
you
mean,
take that position?
I would still say, to be honest, in that circumstance, please like make it foreseeable, if that's the intention. Honestly, I would never be doing my client an injustice. I would be doing my client an injustice there if I didn't speak to the very immediate need to retire in the next 2 years or so, and even maybe a year, I don't know. But no, absolutely. Like, make sure that these things are spoken to. The interesting thing is we've spoken about retirement from a payor's perspective, but not from a retirement from a recipient's perspective. And that might be something that, someone watching this is like, well, what if I'm the recipient and I now want to retire? Like, how does that get taken into consideration?
Well, if the recipient wants to retire from their job so they have less money available to them, is that kind of
You
what
have
you're
less money
thinking?
available to them, and maybe the payor is paying based off of an income, and whether or not they would think that support would continue, and that's a whole other wrench in the scheme of how we've been doing this kind
And
of conversation.
honestly, depending on, I love that because depending on my client, I mean, obviously my client's the payer, then I'm going to just jump right up and be like, nope, we don't care. But it doesn't, of course, it doesn't work that, it doesn't necessarily work that way, right? But yeah, Taryn, that's an interesting one for sure, because if it's a long-term marriage, because the first thing I'm thinking is post separation. Well, these are events, your retirement is something that has happened post separation, and how does this impact your entitlement and all that. But if we're looking at a long-term marriage, and even in this scenario that I gave where someone's so close to retirement, if it turns out that it's the recipient, um yeah, it could potentially be, it is a material change. It is a material change, and we have to go back and review support. I mean, Shireen, what thoughts?
Review support, impute income, like again, like the same circumstances that we have around the payor and their obligation, it's also the recipient's obligation to be self-sufficient in that same regard, or use the same support amounts to become self-sufficient or in that regard. But so yeah, it might be, imputing income to them and continuing to pay the support amounts until the payor is retired. Maybe support terminates because now maybe the payors retire, maybe they're both retiring, in that circumstance, then it's going to be, I mean, I think the support should terminate depending on obviously when you've separated and how long support's been paid and things like that. Yeah, so there's so many different avenues to explore, but
Yeah.
I guess the rule of thumb in this situation is please just consult with a lawyer if you're the recipient, if you're the payor, and retirement is forthcoming. And if you're going through a separation, please make sure that you're speaking to a lawyer who's aware of that circumstance. If you're close to a retirement age, I imagine they would
Share
know.
that information.
Share that
Mhm.
information and your impending need to retire. If you see that being the case, then that's what we should be negotiating and arguing and kind of going through that avenue and finding creative solutions to deal with that that
Is it
situation.
fair? Should we say, I think as a recipient, you probably have a higher threshold to meet if you're retiring, because a lot of recipients just retire and don't recall, and then just leave off whatever support they're receiving. And that's fine, because if you're retiring, absent obviously health reasons and mandatory retirement, I mean, I can't imagine why, if the recipient would want, well, okay, no, that's not correct. I can imagine why they would want to retire and have support recalculated, but I can't imagine that being a very strong argument in their favor, because you have control of sort of what's happening when you're the one trying to retire. But when you're the recipient and the payor is retiring, it's almost an unintended consequence. The financial loss is an unintended consequence for you. But as the recipient, it's even more important that you talk to a lawyer. Like, it's imperative, because you're the one taking these steps, and you can't go take, steps that create financial difficulty for you, and, have any automatic expectations in that sense, right?
And there's the issue with entitlement to post-separation increases in income if you want to vary as the recipient. So like I would obviously say I mean, it depends on who my client is, but
Exactly.
but yeah, honestly, again, like, yeah, seek legal advice, all in all.
Yeah. All right. I don't know if anyone has anything else to add on this topic. Are we done? All right. All right, guys. That's it for today on retirement and its effect on your support obligation. And until next time, it's bye for now.
Bye, guys.